So thanks for inviting me. I feel sort of honoured to be amongst people with significantly more experience than me in this, but I know from sharing an office with Rob for the last few years, he knew that I was doing a course in becoming an expert witness, and so for the last year I've been working with a legal firm in London, and some of the stuff that I'm talking about today predominantly comes from that course. So the good news is some of my talk has already been covered in Tom's, so we should be able to rattle through it quicker and get you to coffee. But first, I thought we'd talk about what actually is an expert witness. Sort of law is obviously all about terminology, and it's probably worth just spending a second looking at this. So a witness is anybody who's giving evidence under oath to a court, in this context anyway. A witness of fact is somebody who's giving a factual account of events to the court, and this would usually be the doctor who'd been involved in the case. An expert is somebody who offers special expertise in a particular field that would be unknown otherwise to a lay person, or in this context, the court. But an expert witness differs from a witness of fact in that they are giving opinion to the court, and they're sort of acting as a translator to turn medical language into language that can be understood by the court in order for them to make a judgment. So the difference is, just to underline those again, the witness of fact will have been involved. They cannot refuse to give evidence. Their attendance would be mandatory. And usually it's first given in the form of a written statement. I would advise anyone who has to produce a statement of fact for any sort of proceedings to run that by their medical indemnity provider, because that's what you pay them for. And there are subtle nuances of language that we're probably not used to that actually need to come across in that sort of evidence. Now, an expert witness, they shouldn't be associated with the claimant or the defendant, and there have been cases where cases have failed because of failure to disclose potential conflicts of interest. An expert witness can refuse to give evidence, particularly, and should do if it doesn't lie within the field of their expertise. But essentially, both witnesses owe a duty to the court that overrides any obligation to whoever is paying them. And that's important. All the previous speakers have already referred to different types of courts. I thought it might help contextualise that for people as well who are unfamiliar. The most likely court that anybody here would be required to go to is a coroner's court, which is obviously non-adversarial and is only seeking to ascertain 5 key facts around the death of a patient. However, there is a criminal court, which Alan's going to talk about more later on, and civil proceedings. And the courts go in that sort of order of arrow of seniority or complexity of case. So they always are heard at the most basic level and then referred upwards. And as David's just pointed out, majority of medicolegal cases are heard at the High Court, which sits just underneath the Court of Appeal. And tort law is that is split into lots of different divisions, but the Queen's Bench, or when she dies, the King's Bench it'll become, is where medical negligence cases are heard. So the process, this is the bit that Tom's already alluded to a lot, essentially boils down into that pre-action protocol, which I'm not going to go into lots of detail now because it's been covered. The aim being to try and settle before it reaches exorbitant legal costs, followed by the sort of proper instruction if it has not been resolved, followed by the response, which is where people here would be expected to give evidence, and also where trusts or claimants may appoint expert witnesses, and that will certainly be required for proceedings to continue. So expert witnesses are approached by solicitors, and I thought I'd put a bit about how to accept instructions in here. The key thing is that whatever you're commenting on has to be within your field of expertise. There are a whole load of sort of legal terms, statements and declarations that are quite sort of chunky documents to read the entire bit, but there are statements that you have to put in any report saying that you're aware of them. And I think it's probably worth thinking about them if anybody is instructed, because provided that you can reassure yourself that you can conform to all of these regarding that specific case, then by definition you are an expert and qualified to comment on that case. The timescale and quality of the report is sort of your advert. So, I mean, some medico-legal experts heavily market themselves, but the marketing is in the thing that you're delivering, so it has to be good, because otherwise you're not going to get repeat business, if you like. The terms, conditions and fees need to be set out in advance, and in advance of you accepting instruction, because once you do, that becomes a potentially long, sort of legally binding obligation to continue to advise proceedings, up to and including going to court. And once formal legal proceedings have been initiated and the case has been assigned to a track, then actually there's a whole load of dates that go way into the future that you would be expected to be involved with at certain points. Now, they can be moved a bit, but it sort of shows that they're trying to operate to a very strict timetable for these cases. Importantly, your contract as an expert witness is with the instructing solicitor. It's not with the claimant or the defendant, depending on which side you're working for. So the report itself has to conform to a specific standard. And these differ slightly depending on whether it's a civil claim, a family claim, or a criminal case. And the report must comply to that standard, because if it doesn't, it could be potentially inadmissible. It needs to contain a purpose of why you're writing it and a summary at the beginning. I wish I'd known this when I first started doing this work, because it sort of initially was reading as a sort of story with the conclusions at the end, like you would do in a sort of, reading an article in a journal, and it lacked the abstract, if you like. But that's really crucial to have that at the beginning, because then they have a clear idea of where this report's going. You've got to include your instructions from the solicitors, and you have to ensure that every bit of those instructions have been addressed, unless it's something that you feel falls outside the area of your expertise. You should identify the key questions that your report seeks to address, and you have to declare where your sources of facts are and what assumptions you've made or inferences you've made during the formation of your opinion. But the crucial thing, and one of the things that barristers have told me that a lot of medical reports lack, is the reasoning behind conclusions. So it's not getting from A to B, it's how did you get there? They have to include those statements that I've talked about before, and they have to include appendices, but particularly for complicated reports with lots of medical terminology, a glossary to aid people's understanding. What reports probably shouldn't contain is lots of legal inferences, because we're doctors and we're advising on medicine, not on law, and I think it just irritates barristers. So what sort of things do we look at? All of this forms the bundle, so you're sent now electronically a whole load of notes, which include medical notes, nursing notes, radiology reports, x-rays, GP records, dental records, all sorts of things. And importantly, the statements from the witnesses of fact who are involved in the case. Now, sometimes you'll be asked to compile a report without looking at that, or without looking at a serious incident report, and then they want you to look at those separately and then decide whether the new evidence that has come out from those interrogations changes your opinion at all. You get to see all the correspondence between the claimant and the defendant, and you utilise local guidelines, importantly, and national guidelines that were applicable at the time of the incident. So that's difficult, and David's already alluded to that you have to put yourself in the shoes of the person at the time, and of course that may be several years prior to your report. So how do you protect yourself? I'm pretty sure this is the take-home message from everybody's talk so far, is the records. It's absolutely crucial that these are clear, accurate, and contemporaneous. And that's coming from somebody who can barely write. So I can't wait for the day we go digital because my writing's so atrocious. They need to be timed, dated, signed. If you've had a difficult decision to make clinically, then it's important to document the reasoning behind that decision. So it's not the decision, it's the weight is given to how you arrived at that decision rather than the decision itself. And it's important to write why you did things and why you didn't do things in the medical notes as well. One thing that can help in a sort of anaesthetic catastrophe is that you actually almost do a sort of rough draft of your contemporaneous record before putting it into the medical notes, because once they are written, they are there. And even if they get crossed out, they can still be, that still forms admissible evidence. If you deviate from the norm, explain. There's lots of reasons why we go against guidelines, but you have to write why. If you didn't obtain consent for something, you have to write why. But the GMC do have this very specific phrase, which is probably pertinent to anaesthesia, which is if a patient needs the treatment to relieve serious pain or distress, you can rely on oral consent. So typically, when I'm putting in an epidural as a rescue thing for somebody who's got a smashed up chest or somebody who's writhing around in bed in agony, I don't make them sign a consent form because in many ways you could argue it wouldn't be valid. But the GMC actually backs that up, but you just need to write why. And of course, if you've done something wrong, you must apologise. Most claims that are brought against doctors there's been no evidence of negligence, and only a tiny proportion of claims where there clearly has been negligent care do they result in a claim. But a key thing when you ask, when people have asked patients why they're suing, there's something to do with a breakdown in rapport, breakdown in communication, particularly in things like primary care or surgery, where they just think that something went wrong and nobody said sorry, and if they'd said sorry, they might not have done anything more about it. So I think it is probably quite important. Now, fortunately, hardly any, David's just told me it's actually 0.8% of cases actually get to trial, and that's good because it sounds like it's probably awful. I've only ever given evidence so far in coroner's court and in fitness to practice hearings, not in high court. But as I've already said, the expert witness's role is to help the court reach the decision, but the lawyer's goal is to win, and they don't care what they do, they don't care how they get there, but the ultimate goal is winning, not whether something's right or wrong. It's just about the winning. So therefore, you've got to be prepared for that. And you have to know your evidence inside out. You've got to correct any errors before they come to court, because it's embarrassing if that's the first time they're revealed. It's a good idea for witnesses to look at their own report critically and identify what the strengths of it are and what the weaknesses are, and then prepare for questions about those weaknesses. You do get to read the other side's reports, obviously, in the preparation of the joint statement, but you have to plan for those questions. And your own lawyers can't counsel you on your evidence. It's against their sort of code of practice. And so therefore, colleagues can, but the lawyers can't. So it's important that you sort of prepare for that properly without their assistance. And that's weird when a case adjourns when you're in the middle of giving your evidence, because actually you're not allowed to speak to your counsel at all. So they will, if you're walking out of the witness box, as you go to sit beside them, they will actually turn around so you can't see them. So apparently that's a very weird experience if you don't get to give your evidence in full, because you can't talk to them at all about anything until you're back in the witness box. So the frightening bit is obviously this, the cross-examination. And traditionally that was sequential, so you'd have the claimant's expert first, followed by the defendant's expert. But increasingly that's becoming concurrent, or what people call hot tubbing, where both witnesses are put into the witness box at the same time and just sort of rapid fire questions and trying to thrash it out with them concurrently. But the purpose of this is basically to either undermine the evidence from an expert or to undermine the expert themselves. or it may be to put forward a complete alternative as yet undisclosed explanation. But the purpose of cross-examination is to find the weaknesses, and that might include gaps in reasoning, unexplained conclusions, or errors or omissions. And these things, having seen a part of this course, you get cross-examined for a day by a barrister on a report that can be fictitious or closed. And when there's even the slightest tiny mistake in a report, they sort of latch onto that, and it's awful, because basically everything, they just make you look so stupid. So making sure that everything's correct is really crucial. How do they do that? The first time I was asked about my report, it was a defendant report, and the barrister just, it's all a bit weird, it's a bit sort of like a simulation-y course thing, and you go and stand up at the desk, and she said, Dr. Harber, I take it that you're aware of the catastrophic failures that resulted in my client's injury. And you sort of, I don't know whether to say yes or no or nod or what do you do. So they might try and derail you right at the beginning and force you into a corner. A credibility battle by making out that their expert's better than your expert. That's common. I've already said about mistakes in the report. So there was a guy who was up before me, and he'd got it was something like a name or a date or a time, something small, wrong, and they were totally onto it. And they said, whatever his name was, Dr. Smith, are there any other errors in your report that you'd like to correct now for the court? And I sort of looked through, can't find. And then they said, can you turn to page 14? I'd like you to read out paragraph 7 to the court. And so he reads this out, and in that is another error. At which point they say, may I remind you you're on oath, which is sort of legal speak for you're lying, and it undermines all their credibility. Other techniques, drilling questions, so that's where you ask, I put it to you that this happened, and the reason for that was because of X, Y, and Z, and that you did that on the basis of this. And there's too many parts to it. So the first bit might be true, and the last bit might be true, but the middle bit isn't. But you get hung up on the last bit and might agree to something that's hidden within the context of that sentence. So if that happens, the best way to deal with that is to split that up into each bit. Initiating arguments, so that just makes you look bad if you start arguing with the barrister. Interruptions, so they ask you something, you start answering, the barrister thinks that isn't going to go the way they want, so they stop you and try and get on something else. But if you feel that is a key part of your evidence, then you have to address the decision maker and say that it's important that you continue, but that's hard. Speculative questions, that's a bit weird because you don't know because you weren't in that situation. This is difficult, so I was put on the spot with the barrister just saying, just answer me yes or no, is this a possibility? Or was that the correct thing? And there is no yes or no sometimes. So you have to say that. You say, well, actually, it would be misleading to the court if I said a simple yes or no, because, and then go into the detail behind that. One thing that somebody told me that some barristers do is they call you by an incorrect name, and they keep changing your name, just or to make you feel, one, to rile you, and two, to sort of give the message that they're in control and you're actually quite inconsequential to the process. Long silences, so that's sometimes used to make you just start talking and saying something that you shouldn't do. And I think this probably is not perhaps that common, but one of the people told me that there's a famous barrister who, as soon as somebody starts saying something they don't like, they just push all the papers onto the floor. So you're in the middle of giving your answer, and there's complete mayhem with bits of paper floating around, and somebody trying to gather it all up, and it's just to derail and stop you talking because what you're saying isn't the direction they want you to go in. So that sounds awful, doesn't it? But there are some other pitfalls as well. So basically, losing objectivity, the most important thing And that is something that Alan Aiken had told me, is that your report has to be able to be used by either side. It should be balanced and objective. And people who hold very, very strong views, so sort of this is where the world expert in something, they're so convinced that something's true, they fail to see anything other than their own opinion. Straying outside your area of expertise is dangerous. Going against previous opinions, so that's probably more common for somebody who is an expert in a very particular field, who says something in this trial that they've said the opposite of in a previous trial, because if they're well known, then they dig that out and they just make them look silly. Failing to declare a conflict of interest, so this was the case of the neuroradiologist I was talking about briefly earlier. This is somebody who knew the person that they were defending, and that came across in court because he used the doctor's first name in the witness box, which the judge thought was odd, and it only came out in court that they'd worked together, they'd written publications together, he was his trainee, and he'd supported him getting a job somewhere. So it looked bad, even though the evidence may have been perfectly valid. Incorrect form of report, I've talked about that already. Changing your report at the request of lawyers. I've never been asked to do this, I don't know if you have, but asked to that you may have written something that doesn't help their claim, they may ask you to remove that, but if it's important, you really shouldn't do things like that. Failing to read everything, and failing to indemnify your work. So most people who don't do very much for this, like the MPS, include this in your normal indemnity. But if you're doing lots, or your proportion is very high, you have to declare that, and that can be at additional cost. So more cons, there are some pros in a minute. But until quite recently, I think it was 2014, but I might be wrong. Yeah, about that. Expert witnesses were immune to suit or prosecution, and they were still at risk of perjury or contempt of court, which are criminal charges. But because serious miscarriages of justice have occurred due to poor conduct of expert witnesses, that law has changed. So there's about 400-odd year law that has been changed, and you are now exposed to liability for costs arising from your role in proceedings. You can be exposed to regulatory or disciplinary action. You can be exposed to having your identity made public and sort of condemned in the press. And you can be exposed to the risk of a civil suit against you if you fail to give your evidence in the correct manner. Formal training is, I found, very, very helpful, but it's extremely expensive. I think the course is about £2,500, something like that. It's an expensive few days. And so I asked John about this, and John says the problem with doing lots of medico-legal work is that it does give you a slightly skewed view of risk, because you're only ever seeing the disasters, so you're never seeing normal things that don't go wrong. But the pros are, it's interesting, it's still work, but you know, as my gran used to say, change is as good as a break. It might help people with their own risk management, because you're able to sort of see things that are happening up and down the country, and what is this responsible body of opinion. You get a better view when you work in one centre. You obviously get quite ingrained in the way that Nottingham do it, or Leeds do it, or Leicester do it. You do get paid for it, obviously, but eventually that can take an awfully long time. But importantly, and probably why we're here all today, is the GMC specifically state that essentially, if you do work like this and you are experienced and trained in it, then you should share that experience and training with your colleagues, because you've got valuable insight and help that you can give them when they are faced with the inevitable situation of having to give evidence in either orally or in writing. So in summary, it is interesting. What I've learned is that law is much more traditional than medicine. In fact, even to the point where if people sometimes sit in the wrong place in the court by a chair, the judge will ignore them, or if they're not senior enough to be in that position, they say, "I'm sorry, I can't hear you. I'm sorry, you'll have to speak up," until they realise that they've sat too far forward and they need to be a row behind. It's bizarre. It's a steep learning curve doing this sort of work, and I think training is essential. the lawyers just want to win, that is the take-home point, but you've got to be impartial to that and present a balanced view. There's lots of resource locally, so David Bogod, David Levy, John Harber and Alan Aikenhead all do loads more than I do. So tap into that resource if you ever need to. All right, thank you very much.